Hello, hello, hello. Hello, 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 hello. Huh.
It becomes
Hello, 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 hello. Hello, 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 hello. Hello. Hello, 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 hello.
Hello, 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 hello. হ্যালো এটা বন্ধ করে দাও
Hello. Namaskar and good morning to everyone. All are requested to put their phone on silent mode.
Hello, 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 hello. Sir, please maintain silence, please, sir.
হ্যালো হ্যালো
घन घन भन भूमिराजित अंगे नीलबुधर मल साजित रंगे कल कल मुखरित चारु विहंगे जननी 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 वंदे उत्कल जननी वंदे उत्कल जननी सुंदर सारि सुशोभित क्षेत्र ज्ञान विज्ञान प्रदर्शित नेत्र जोगी ऋषि गण उत जप पवित्र जननी
Sir, please sit down, sir. May I now request respected Judge Koraput, Sri Satyanarayana Mishra sir, to kindly deliver the welcome address. Sir, please.
A very good morning and namaskar to one and all. From my experience as an advocate and subsequently as a judicial officer, I have come to realize that adjudication often takes time. Adjudication not only at times leaves a trail of bitterness behind, but also casts a shadow upon the future of parties litigating before courts. We are conscious of the fact that not all cases require adjudication. We all are aware that normally disputes relating to property, matrimonial disputes, industrial disputes, disputes arising out of contractual obligations can really be resolved through mediation, which is one of the modes of alternative dispute resolution mechanism. Provisions such as 89 CPC, Order 10 Rule 1 CPC, subsection 2 of Section 23 Hindu Marriage Act cast a duty upon courts to send matters in dispute for resolution through alternative dispute mechanism. So, in my humble view, mediation is one of the modes which provides a golden way for resolution of dispute. Mediation not only resolves a dispute, it removes the very cause of the dispute with the amicable settlement between the parties. We are really honored and we feel it is privileged that we have been selected by the Honorable Court to organize this program of 40-hour mediation training. I would like to submit here that in my view, advocates are the movers of alternative dispute resolution. Advocates are the persons who can convince the parties in a better way to resolve their dispute through mediation. Advocates have the freedom to interact with the parties freely. So, on this momentous occasion of the inauguration program, I express my hearty welcome to my Lord Dr. Justice S.K. Pangrahi, Judge, High Court of Orissa, and the Administrative Judge of Koraput Judgeship. My sincere regards, my Lord. Your gracious presence on this occasion is a matter of great honor for us. I also extend my hearty welcome to Honorable Miss Justice Savitri Ratha. Actually, ma'am requires no introduction. We all are aware about ma'am. Whenever we open a book, we see her name. Ma'am is the Judge of Odisha High Court and also the member of Mediation Monitoring Committee. Madam, your gracious presence in this inauguration of this program is a matter of great privilege and honor for us and has greatly encouraged us. I also extend my warm welcome to Honorable Sri Justice M.S. Sahu, Judge Odisha High Court and the member Mediation Monitoring Committee, High Court of Orissa. Your Lordship, your presence in this inauguration is a matter of great privilege and honor for us. I feel obliged to express my sincere regards to the Honorable Judges to have graced this occasion travelling long distances. I also extend hearty welcome to Judge Tenor MCPC Madhya Pradesh, Mrs. Giribala Singh, to have taken pains to travel to Jeypore to provide training to advocates. I also extend my hearty welcome to Judge Tenor MCPC Maharashtra, Mr. M.K. Yadav, to have taken pains to travel to Jeypore to provide such training to the advocates. We are greatly honored, sir, for you being the part of this program. I also extend welcome to my brother Samyak Pratra, Coordinator, Arbitration and Mediation Center, Honorable High Court of Orissa, to be a part of this program. I also welcome Sri Srujan Saraswat, Assistant Secretary, Orissa State Legal Services Authority, to have come to Jaipur to be a part of this program. I also welcome my brothers and sister Judicial Officer of Jaipur to this inauguration program, and I thank them for their help in organizing the program. I also welcome the presidents and other office bearers of Bar Associations of Jaipur, Koraput, Chimliguda, Lakshmipur, Kotpad, Boriguma and Dasmanpur to this inauguration. I also extend my hearty welcome to the learned participating advocates of 5 judgeships who have come to Jaipur to take part in the training program. I also extend my warm welcome to other learned advocates who have graced this inauguration with their kind presence. I sincerely hope that this 40-hour training program will provide us with a dedicated team of dynamic advocate mediators who will ultimately help the institution to resolve more and more disputes through mediation. Thank you very much.
Thank you so much, sir, for your warm words of welcome. May I now request the learned President of Jaipur District Bar Association, Sri Biresh Patnaik, to kindly deliver his address. Sir, please.
First of all, my namaskar and pranams to all. The District Bar Association Jaipur extends its heartiest welcome and gratitude to honorable dignitaries on the dais, Honorable Sri Justice Malkangiri Sahu, Honorable Dr. Justice Sanjeev Kumar Panigrai, Honorable Miss Justice Savitri Rotho, all the dignitaries of the dais and the resource persons and the members of advocate fraternity. All the judicial officers, we, the members of District Bar Association, are grateful and thankful to Honorable Chief Justice, High Court of Orissa, Dr. S. Muralidhar, and all other honorable judges of High Court for choosing this place for establishment of regional judicial academy, virtual High Court, digitalization, and all such revolutionary changes in the Judgeship of District and Session Judge Koraput at Jeypore. Coming to the subject of mediation, the purpose of mediation is to clear up misunderstandings, determine underlying interest and concerns, find areas of agreement, and incorporate the area into solution devised by the parties themselves. There are two types of mediations. One is evaluative and one is facilitative, and the facilitative mediation is generally preferred because it protects the interest of the parties and relation. I am very much thankful that I have been given an opportunity to speak a few words on this occasion. So thank you, and I am concluding my speech. Bande Utkal Janani.
Thank you, sir, for such a short and profound address. It is my utmost privilege to request Honorable Sri Justice Malkangiri Sahu, Judge, High Court of Orissa, to kindly address the August House. My Lord, please.
Namaskar, very good morning to all. My esteemed colleague, Honorable Justice Panigrai, the Administrative Judge of the District of Koraput, my esteemed colleague, Honorable Justice Ratha, Member Mediation Committee, High Court of Orissa. the Registry of the High Court represented by the Coordinator Mediation Center, learned District Judge and learned Judges of the Judgeship present. And this, I make a special mention of the learned expert trainers, Madam Singh and Mr. Jadhav, who have travelled all the way to impart the mediation training. Learned President who is present and other members of the legal fraternity, the lawyers of Koraput, Kalahandi, Rayagada, Nabarangpur, Malkangiri who are present here, officials of the government who are present, members of the print and electronic media. It is indeed a privilege for me to be present amongst all of you on this special occasion for inauguration of this intensive 40 hours mediation training program. I take this opportunity to give a brief background of the subject of mediation to the learned members of the bar. In fact, it was also mentioned by the learned district judge. I refer to section 89 of the CPC, especially where it mentions but for the laudable objective it was upheld to be valid intra vires in Salem Bar Association's case, which all of you know, Salem that won. In this context, I request learned members of the bar to refer to the erudite judgment rendered by Honorable Supreme Court in Afghans Infrastructure Limited versus Cherian Varke Construction Company, a judgment rendered by Honorable Justice Rabindran, who is kind of a, he evolved this concept in all his judgments. They are actually the Afghans decision that deals mediation as a alternative dispute redressal mechanism highlights that it's a third party adjudicating the dispute between two persons, which is alternative but strictly not in parameters of judicial sense. There it is also highlighted. In fact, I was told that this institutional mediation is yet to start here. So why institutional mediation is important? Because if you go through that Afghan's judgment, it highlights that since you are referring to a third person, whether the court records have to be transmitted to a person who is not part of the judiciary. But in a institutional mediation center like Mr. Patra is there, he is in charge of everything. We are referring from High Court to the mediation, all these records. So those kind of difficulties are not there, because it is a recommendation that a copy should be sent to the mediator, not the entire case records. That is advantage. Now I would also request that a recent lecture delivered by Honorable Justice P.S. Narasimha of the Supreme Court, he was addressing the Supreme Court Bar Association. Regarding this mediation as alternative, Honorable Lordship has highlighted this duration of litigations. Like it is also highlighted earlier, family disputes, partition suits, whether the 70 years of adversarial litigation has really helped. Because generations together, in fact, as my experience as a lawyer will tell you that generations together, 3 generations are fighting for partition. So there, one has to think about whether this adversarial system has suited Indian context in adjudicating these matters. Second aspect, why lawyers have to be trained. Please appreciate this mediation code is pending to be approved by the Parliament. It will be made compulsory. There is a proposal, before any adversarial litigation there has to be a certificate that mediation failed. So now since a third party is mediating, we require more number of mediators. Also please appreciate that. I thank and congratulate all of you. Vande Utkala Janani. Namaskar.
Thank you, my lord, for enlightening words. May I now humbly request Honorable Miss Justice Savitri Ratha, Judge, High Court of Orissa, to kindly address this august gathering. Madam, please.
Namaskar. A very good morning to everybody, and a very warm welcome to Mrs. Singh and Mr. Jadhav, who have come so far away from Maharashtra and Madhya Pradesh to be with us. Today when we travelled, we came from Cuttack by train, to Koraput and by road from Koraput to Jeypore this morning, and I was wondering why haven't I come to this place. And I'm thankful for this opportunity that I've been able to come to Jeypore. It's beautiful, such natural and sylvan surroundings. I'd only heard of it. I'm overwhelmed. And now back to the topic. Honorable Justice Dr. S.K. Panigrahi, Honorable Justice M.S. Sahu, my esteemed colleagues, member mediation, Justice Panigrahi, as you all know, is the administrative judge of Koraput district, and Justice Sahu and me we are members of the mediation monitoring committee of the Orissa High Court. The district judge Koraput, Mr. Mishra, the other judicial officers who are present here, the president and secretary of the Jeypore Bar Association, the 25 advocates who have come from the 5 districts to be trained here these 5 days, members of the bar, and members of the bar of the 5 districts who have come here, and of course Mr. Patra, who is the coordinator of the Arbitration and Mediation Center of the Orissa High Court. Ladies and gentlemen, as Mr. Mishra and Justice Sahu have explained the background of mediation and the legal legislative pronouncements on that aspect, I will just give a brief background of what is mediation. Most of us know it, but even then, to refresh my mind and to refresh all your minds, the process of mediation is, as you know, is completely voluntary at all stages, and it only can take place if the parties to the dispute voluntarily agree to the terms of dispute, then dispute can be settled. Neither the mediator nor the court or anybody else can compel the parties to come to a settlement or to agree to any term of settlement. And if at any stage of the proceedings, any of the parties don't want to continue to take part in the mediation process, they can withdraw from the mediation at the terms on which the dispute should be settled. He or she can only generate the options for settlement, and that too subtly, without the parties feeling that it is he or she who generated options for settlement. And the entire mediation process is confidential. The parties don't have to worry that what they share during mediation or discuss during mediation will come out in the media or in the to knowledge of the public. And any statement made in the mediation process by any of the parties, even if it not acceptable or unpalatable, cannot be used as evidence or even referred to in the court during the proceedings, trial or appeal. For example, I am now sitting in a division bench hearing matrimonial appeals. Number of cases we have referred the party mediation, but they have not come to an agreement. Probably sometimes the husband doesn't agree, but the wife doesn't agree. But that cannot be used against them in those cases the mediation fails. But that cannot be used against them when we are deciding the appeal. The appeal has to be on the basis of evidence on record. So, the mediator also is statutorily prohibited from being summoned as a witness in the case between the parties to depose regarding what transpired during the mediation process. And the mediator cannot disclose any matter revealed during mediation by the parties to any third party. And the parties are also prohibited for introducing anything that happened during mediation as evidence in the case during trial. Therefore, even if the mediation does not culminate in a settlement acceptable to the parties do not lose anything by opting for mediation to settle the disputes. Participation in the mediation process will not in any way affect the case in court adversely if the mediation ultimately fails. Consequently, unlike in other proceedings, the parties can vent their feelings and express all the sentiments in respect of the subject matter during the proceedings, as they can directly communicate with the opposite parties. Unlike in court, when the parties usually act only through the counsels. Therefore, mediation should be practiced as the best form of dispute resolution and not merely as an areas reduction method. Because sometimes, right now, we have what is that? Continuing permanent Lok Adalat, where retired judges try to mediate between parties and solve the dispute, but that is because of pending cases. But as Justice Sahu was saying, the best form would be before parties go to court and start a litigation, they should adopt mediation so that before that long drawn, expensive, sometimes it is expensive and frustrating, because even if you succeed in one court, there is a process of appeal to the higher court. So, as he said, generations together are involved in litigation without any coming to a decision. In fact, I have come across persons where people having vast property are not able to enjoy it because their siblings are involved in litigation, and only after they die sometimes they come to a settlement, which is frustrating, and which is why mediation should first be adopted. So if there is an amicable settlement, the dispute gets settled, and the best part about mediation is you don't go up in appeal. It brings to an end to that litigation, an end to that dispute. Of course, other disputes may arise, that is different, but that dispute at least will be settled at that stage. Now, to ensure a robust growth of mediation as an effective and institutionalized tool to access to justice, the Mediation Bill 2021 has been introduced in the Parliament, and it is a step that will promote and facilitate mediation, especially institutional mediation for the resolution of disputes, commercial or otherwise, and enforce mediated settled agreements, provide for a body for registration of mediators to encourage community mediation and to make online mediation as acceptable and cost-effective process, and for matters connected therewith or incidental thereto. After the bill is passed, mediation will emerge as a popular and parallel judicial process. Of course, one thing is there, even without a person being trained, you can act as a mediator, but the mediation process may not be very effective. That is why the Honorable Supreme Court, the committee has devised this 40 hours training, so that you are trained, you are prepared to deal with all eventualities, because when you are dealing with the parties, various situations may arise which if you are not trained you may not be aware of and may not anticipate. So once you are trained, you can handle all eventualities. So after you become a trained mediator, you will be an asset to society, as you can become instrumental in settling disputes in the community. The public will not have to run to courts where the settlement of disputes takes time due to backlog of cases, and the decisions of the courts are subject to challenge to higher courts. Procedure of mediation, I need not tell you. Types of mediation. Benefits of mediation, I have already gone through. Just to run through benefits mediations. Results are more satisfying than in litigation. The parties determine the outcome and not the judge. They are fully informed about the outcome and control the settlement, so they know what to expect and are not caught unawares, which happens sometimes in litigation, as you are not sure which way the decision will go, and increases participant satisfaction with a greater likelihood of a lasting resolution. Saves money. There are no litigation costs and usually no future litigation costs. Additionally, court fees are also refunded to the parties, and procedures as per the convenience of the parties. And the one word to describe mediation is that it's a win-win situation. Nobody loses. Both sides win, because even if there is no mediation is not successful, no party will suffer any negative or adverse consequences. So with that, I end my address, and Justice Panigrai, who's most erudite here, because he has, in fact, I take his advice sometimes on the various aspects, including these things. He will educate you, and thank you very much for giving me a patient hearing.
Thank you so much, Your Ladyship, for such illuminating words. May I now request Honorable Dr. Justice Sanjeev Kumar Panigrai, Judge, High Court of Orissa, to kindly address this august house. My Lord, please.
Good morning, everybody. Good morning, all the participants and those who are the trainee and the trainers of this gathering. And I must welcome my sister Justice Ratho and brother Mruganka Sahu. We have, from yesterday, we are planning to come here to the serene city of Jeypore, Koraput and Jeypore, I would say, which is in fact the less, I would say, less explored cities of the state. In fact, we have failed to marketize our beauty in the international and national and international forum. So this is what we feel when we were coming to this city. So hope through you are all the brand ambassador of this city, being a lawyer of this city. So coming to this, the initiative of the training for the lawyers, mediation training. This is one of the, I must thank to our Chief Justice, Dr. S. Muralidhar, who has taken a lot of initiative to train our lawyers, be it the hand-holding training for the computer awareness of the lawyers, or maybe the virtual court, and now he is focusing on the mediation training. And Koraput is chosen as the first city in the state to have this kind of training session. So I welcome all of you, all the advocates. In fact, I must welcome to the two mediators who have come far away from here, and I hope they will take a good memories from the great city of Koraput, and also they will have a satisfying teaching experience, or I can say the training, as a trainer to all of the lawyers who are present here from 5 districts, I am told. So when we talk of mediation, we often find that let's go to Mahabharata age. So during that time, you find one of the greatest mediator on the earth was Lord Krishna. You must have seen in Mahabharata. He tried, though as a mediator, whether he failed or succeeded, that's a different thing, but he was a great mediator. And later, during that phase and later phase in our Indian society, in the rural area, we find mediation has been one of the most potent instruments for dispute resolution. Most of the people in the rural areas, even today, even in Koraput, you go to the interior village, there will be village punch. 2, 3, 4, 5 people will be sitting, the headman of the village will be sitting there, and they will solve their problem. So mediation is nothing new. It is one of the oldest. It is as old as the civilization itself. Because when civilization is there, people will be there will be dispute, and dispute has to be resolved. And since dispute has to be resolved, and this is one of the most, ancient method of dispute resolution, though modern touches have been given to this thing. Later you have, this has become one of the most potent instrument of the alternative dispute resolution. So, once Mahatma Gandhi said, I had learned the true practice of law. I had learned to find out the better side of human nature and to enter man's heart. I realized that the true function of lawyer is to unite the parties involved in a dispute. The lesson was so incredibly burned into one that the large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, and certainly not my soul. This is what Mahatma Gandhi once said about the dispute resolution, and this is also applied to this. This is also another method of because alternative dispute resolution. Similarly, I would like to put in another way, so which you I think will. But sometimes litigation held to be the vanguard of dispute resolution for the civilized society, but quite lately, it has been disheartening to see the litigation losing its charm because of the time-consuming factor, or what we call, there are many barriers to justice. The time is and money is one of the most important barrier to justice, and therefore, to overcome that barrier, this is one of the most important instruments. I will give you an example. For example, the litigation route has been like the Mo bus. You know Mo bus? Even in Orissa, there is more bus, every city you have more bus. So the driver who looks at you at when you are running to the bus station, yet he drives, he doesn't stop. He has, to catch the bus, you have to be in time, you should have money, everything. So this is like more bus. So therefore, if you want to go by the more bus, if you are strong enough, you can walk also to some extent. And if you are still strong enough, you can cycle also. You can have your own vehicle like that. So litigation has actually it is like more bus. So this is likely to, you are likely to miss. So therefore I say the old methods of mediation as an old method, it has to be codified now. Of course, steps are being taken to codify the mediation, and hope gradually the mediation it is quite popular, but still it is not as popular as it should have, because the factor is most important factor, that is the inhibiting factor, I would say, that many of the lawyers we are not trained actually. That's why the trainers have come all the way from Madhya Pradesh and Maharashtra. So they should train, and hope then we have to have our own trainers. We should have a brigade of our own trainers. Again, you will train your fellow. This chain should continue. Then only this mediation will be popular. So training, this is what you are training. You are getting the training from them, and then you will train to your fellow friends. So this is how you have to just pass on whatever you learned, because this is also a skill. Mediation is a very skilled. So we don't find so many skilled mediator in our country. Because of that, one of the important reasons why the mediation has not become so popular. Secondly, mediation has been it is confined to mostly the court-monitored mediation. Most of the time the court says, okay, go to the mediation, then you go to the mediator, then. But pre-litigation, the mediation is hardly taking place. So this is now time has come that every litigation should be preceded by some the mediation process. Then only we can popularize the mediation, and it will definitely, as Madam was telling, it is a win-win situation for all the parties. So nobody is going to lose. So both parties actually wins. I have my personal experience. I was doing a case in Supreme Court when I was a lawyer. So I was arguing a case for about 3 years. That matter was every day the matter will be coming, the parties will be coming, and they will have a very pale face. Sir, kya hua? Aaj bhi nahi hua. Fir again another date. Again you will come. Sir, kya hua? This is how it went on. Then the judge he said, since the dispute because the dispute was because of the adopted son, whether he was really adopted or the mother, that was the dispute. So dispute went on for so many years. They fought in High Court for about 10 years, the Supreme Court for 3 years. Then the judge referred to the mediator. So mediator was referred, and it was within 6 months the problem got resolved, and both the parties are happy. So this is how the beauty of mediation. Had it been in the pre-litigation stage, the party would not have wasted so much time and energy in just solving the issue. They had taken just 15 years. Can you imagine? And in many cases, for 40 years, 50 years, there is Supreme Court one case I have just seen. That for 60 years that litigation is going on between two brothers from Punjab. One case it came to Punjab, and finally it was referred to by the Supreme Court judge. Go to the mediator. Some Punjab High Court judge was appointed as mediator, and finally it was reserved. 40 years they lost. So important period of their life they lost in fighting the litigation. Nobody enjoyed the fruit of the litigation. Finally, you just got the benefit out of mediation. So why not the mediation be given the precedence over litigation? So this is how, since all of you are here to hear from them, I should not stand between you and the experts, because I don't know much about the mediation. They are the experts. They must be telling you the skill. They are the skilled people. They will tell you the trick and all these things. So I'm a layman in that area. So I know mediation is good, bad, whatever. But they will tell you what is the process, how you have to address the issue, and how you have to just bring resolve the dispute. Everything they will tell you. So hope the session will be very fruitful and everybody will be learning. And I am just want to see that the mediators in the state should increase in a geometric progression, not arithmetic progression. Thank you. Thank you.
Thank you, my lord, for your enlightening and heartfelt words. Moving on now. Now may I request my lords and my ladyship to kindly accept the mementos as an expression of respect and gratitude, and for that may I request respected District Judge Koraput Sri Satyanarayan Mishra sir to present the memento to Honorable Dr. Justice Sanjeev Kumar Panigrahi, High Court of Orissa. May I request respected District Judge sir to present the memento to Honorable Mr. Justice Savitri Ratha, Judge, High Court of Orissa. Now may I request the District Judge sir to present the memento to Honorable Mr. Justice Mogangasakar Sahu, Judge, High Court of Orissa. Now, request the staffs of civil court to present the memento to the dignitaries. Madam. Now, may I request respected the Judge Family Court, Sri Pavitra Mohan Samal sir, to propose the vote of thanks. Sir, please.
Namaskar. Greetings of the day. I feel proud and privileged to be proposing vote of thanks on this momentous occasion. Mediation an ounce of mediation is worth a pound of arbitration and a ton of litigation, said James Bomjom. At the time when we are experiencing case load, day in and day out, it is heartening to observe that the ADR mechanism, especially the mediation, is an important tool to address the issue. Today's 40 hours mediation training program is one of the more significant move to make an environment conducive to the mediation. It is going to be a memorable day for all of us, for sure. We express our deepest gratitude to the Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, High Court of Orissa, Administrative Judge, Koraput Judgeship, Honorable Miss Justice Savitri Ratho, Honorable Mr. Justice Murganga Shekhar Sahu, Judge, High Court of Orissa, members, Mediation Monitoring Committee of the Honorable Court, for your Lordship's benign presence, inspirational and insightful deliberation, and we are fortunate for having your Lordship's presence with us. We owe a debt of thanks to the most important brain on mediation, Mrs. Giriwala Singh Madam, and M.K. Yadav sir, for taking task, traveling to this remote district of the state to impart training to the mediators, that the advocate mediators, for a long 40 hours. We also express our heartfelt thanks to the Registry, Honorable High Court of Orissa, Member Secretary, Orissa State Legal Service Authority, and grateful of encouraging presence and assistance of Sri Soumyak Patra, Coordinator, Mediation and Mediation Center, High Court of Orissa, and Assistant Secretary Saspat Sir, Orissa State Legal Service Authority. I take this opportunity to extend my heartfelt thanks to the trainee advocates and congratulate them to have a good interactive session with our trained mediators, judges, trainers, and to extract as you can to implement in the field to help the common litigant public. I would be remiss if not I mention the name of Secretary District's Legal Service Authority Suman Jana and his team for tireless effort to making this event successful with the help of our district court staffs. Finally, I would like to thank our district judge sir and my brother and sister judicial officers, and also thank President Bar Association, office bearers, and erudite bar members present here to apprise us. I also thank one and all present here and watching virtually through live streaming YouTube, and whose name I didn't mention due to paucity of time, for making this eventful morning for all of us. Thank you, every one of you. Bande Utkal Janani. Namaskar.
Thank you so much, sir, for your kind words. Now, may I seek the permission of Honorable Chair to declare the function closed. The function is declared closed. And the judge, trainers and participants are also requested to remain at conference hall of Regional Judicial Academy. Thank you.